Welcome. This afternoon we have Michael Gullo and my partner, Christina O'Shea. And one of our favorite things to do and to talk about is EUOs, examinations under oath. Good morning, Christina. Good afternoon.
Good afternoon, Michael. How are you?
I'm fantastic. So Christina and I often do EUOs like this, where we will work on them together as a partner, kind of, as police detectives would have partners, so do we. We get on these examinations together, especially on the complicated fraudulent claims, so that we can ensure that we do these the right way and get all the information that we need. Today's training module is our objectives here, whether you're a new adjuster or you're transitioning or you have a ton of experience or an SIU rep and you'd like to just get an overview, make sure we're all on the same page. So understanding what it is, what an EUO and where it comes from, the differences with the timing and the contractual rights and where they originate, why we would request an EUO, the internal guidelines that are kept, and recognizing how missed EUOs, no-shows, how that works with coverage defenses and summary judgment motions and the documentation required there. And also things to avoid, common pitfalls like late denials or undocumented EUO requests. So before we begin, I will share my screen.
And also, these are things that we see come up frequently, between the carriers and the adjusters. Commonly asked questions that we see arise tend to be the same ones from adjuster to adjuster. Sometimes the regulations can get a little confusing, especially when it gets to timeframes and when to request these. So I think it's helpful for every adjuster to be on the same page as to, like Michael said, what to avoid and how to adhere to these guidelines.
And so, what is an EUO? It's a formal statement under oath given by a claimant or a provider, recorded by a court reporter. These days we do them on Zoom and some of them are recorded. And it's to verify claim details in its most general sense. We investigate fraud, employment, income loss, clarify treatments, the chronology of events, resolve inconsistencies, go over treatment details and patterns of treatment and where they're going and whether or not they receive certain tests. The authority for an EUO is based upon the mandatory PIP endorsement. In the endorsement, it says, as may reasonably be required, we are subject to verification timelines, which we'll get into. And one of the most pervasive things, Christina, I know that we do over and over is that eye for detail on these EUOs in every single aspect of it. You agree?
Oh, absolutely. I think going into it, the best way to approach an EUO is just to be prepared. And that also means the relationships between the individuals that were allegedly in the vehicle at the time, even down to the providers that they're then seeing. If we see consistencies between treatment from occupant to occupant where the injuries don't line up, we're really looking at all of that.
And it's also on the summary judgment motions. It needs to be perfect, quite frankly. There's no room for any error. A digit off on a zip code on a scheduling letter can blow your entire claim. So,
Especially for the good attorneys, right? I mean, a lot
yeah,
of the
of
attorneys on the other
course.
side, they're looking for, especially when there's no shows involved, and a lot of these assigners are not willing to cooperate. So the attorneys on the other side do have a tough time sometimes, and they're looking for technicalities to have these
Always.
dismissed.
Uh, before that, we'll touch more on summary judgment motions and how we can use the results of the EUO. But before we get there, as part of this introduction, we do want to discuss some standards that apply pervasively throughout the entire process, any claims process, but real specifically on these EUOs. We want to do them the right way, the professional way, and the ethical way. And these we need to remember are also non-adversarial. So we want to be courteous when possible. So the first thing is integrity and honesty, professional courtesies. Professional courtesies are given often adjournments to other attorneys, things of that nature, later start time. But on our end, we do everything with the utmost honesty, always with ethical judgment in mind and professionalism, because our reputation matters as a law firm and your reputation matters as an individual insurance employee and for the company itself, more importantly, their reputation's on the line. So we want to do everything tough, yes, but ethically and straightforward.
Right. And as Mike said, we're going to get into summary judgment motions later, but we also understand how judges view these types of claims and these types of denials going into it. And so judges, you should always keep in mind that the general construct of no fault law in general is to keep this honest communication back and forth, flowing communication between the parties. So they do want to see good faith efforts from both sides in terms of scheduling. And of course, we're going to be tough about it in terms of adhering to the guidelines and denying when we should. But like Mike said, if they call for an adjournment or a later start time or so on and so forth, you do want to accommodate within reason because a judge will be paying attention to that when he's deciding your motion.
Agreed. And that leads us right into the next part. I know we spoke about it a minute ago, but the eye for detail is just so critical on how everything has to be sharp and precise and pretty much perfect. As much as possible, human error leading into the next step does occur, but we try to minimize it the best that we can. And what's critical, at least in our office, and I know in the clients that we deal with, if somebody makes an error and it's going to happen, we immediately address it. We're upfront about it and we deal with it and problem solve. Don't focus on the problem for too long. So human error will happen, but it needs to be addressed right away.
Right. And you want to make that as rare as possible. So what we like to do is have at least two sets of eyes on any document that's going out. We like to compare the claims documents that have come in and where we got certain addresses. As Mike will show later, when we give a sample letter of an
Yeah.
EUO, sometimes we'll address them to two addresses because we're not really sure. One was provided with an apartment number, one was without. We want to just dot our I's and cross our T's,
Mhm.
and make sure we're covering all bases.
And that brings us to open communication and flow of information. It's a critical part of it. The goal is to do this quickly. The life cycle of cases and EUOs in general. We don't want these dragging on for 3 months if possible. We want to get them efficiently, get them done quickly, and get them done the right way the first time. And
And
of course,
also,
yes,
not to interject, but
go.
that's relevant in terms of when you are in front of a claimant, you want to lessen the amount of times that they can tell you, oh, I don't remember, I don't recall, I'm not sure, that happened months ago. While
Right,
the information is relevant and fresh in their mind,
right.
it limits that window or that opportunity for them to say, well, I'm not really sure, this happened 4 months ago.
So
If I,
sooner is always
right,
better. Sooner is always
absolutely,
better, no doubt.
because then you can actually address that within an EUO and say, well, how do you not
Right.
remember this? This happened 3 weeks ago, right? So this is stuff that's fresh in their minds at that time, and we're getting the most information out that we possibly can.
And relationships, it's the relationships with the insured, there's the relationships between the attorney and the claims reps and SIU, the relationships with the court reporters, the relationships with the interpreters, the relationships with the other attorneys. Maintaining professional relationships is critical to getting things done. Just makes things move easier, move smoother, and we do understand the value in that. So the relationships we establish with these people, I think, is critical and an important part of our process.
Yeah. And that helps us also in terms of for the adjusters' purposes of even getting the transcripts
Right.
in your hands. Sometimes, we tend to those relationships that we have with even individual court reporters, they'll tend to get us a transcript faster than they may have had the opportunity to do so because they have a lot of cases in front of them that they're now transcribing. But
Yes.
because of our relationships and those that we've fostered with these entities, I think that we do get these transcripts. I would argue sometimes quicker than others. So, like Mike said, those relationships are actually huge. They're very instrumental.
Because they like your relationship. You have a couple of relationships with some interpreters, and they see you, and you know them, and you know how they work. They know how you work, and that
Right.
actually makes things go a lot smoother, for
Yeah.
sure.
Even when you're getting the testimony,
Right.
sometimes you work with certain translators that it might be a little more choppy. And so you
Right.
know who to use for different circumstances.
So, as the next step, we're going to move into the legal foundations. Then we'll be talking about how to properly set up an EUO and again, the eye for detail. And that'll end part one. We'll move into part two, which deals with the no-show, the actual appearance, and things that we ask at the depositions. And then litigation strategy, of course, going over our summary judgment motions, fraud summary judgment motions, some pitfalls and things to avoid, and then SIU collaboration and some red flags that are common to see.